Hello and welcome to Workshops on the Web presented by the Ventura County Superior Court. My name is Joanne Johnson and I am the Family Law Facilitator for the Superior Court. This video workshop consists of a video screen which operates like any other video player with play, stop, and pause buttons. The text version of the presentation is in the right half of the screen. You will need to use the arrows or wheel on the mouse to advance through the text. This video is designed to provide you with basic information regarding the laws and procedures that apply to child support in California. The legislature has deemed that support of children is a high priority and has created many laws which apply to child support. These laws are contained in the Family Code, Rules of Court, local court rules, and the cases that interpret these codes and rules. These laws can be quite complex. If you need legal advice or strategy for your particular situation, you should consult with a private attorney. You may find additional information at the self-help section of the Judicial Council website at www.courtinfo.ca.gov and the Department of Child Support Services website at www.childsup.cahwnet.gov. In California, child support is called guideline child support and is calculated by a complicated formula. This formula can be found in the Family Code, starting with Section 4050. The factors a court can consider in calculating child support are limited to those set forth in this code. The court must consider the income of both parties. Child support is based on net income, therefore information regarding tax filing status, number of dependents, tax deductions such as property taxes, etc., are included in the calculation. The timeshare, or custodial schedule for the children with the non-custodial parent, affects the amount of child support, as there is a presumption that a parent spends money on the children when they are in his or her care. The number of minor children that are the biological or adopted children of the parties impacts the amount of support. However, guideline support is not allocated equally between the children. The youngest child receives the most, with each additional child receiving a lesser percentage of the total amount of support. The cost of health insurance for the parent and family is factored into the support calculation. Generally, parents are required to have health insurance for the minor children if available at reasonable or no cost through employment. Other support orders which a parent actually pays are allowed as a deduction in calculating child support, as a parent has a legal obligation to support all of his or her children. If there is no formal court order, the payor will have to prove that he or she voluntarily pays for the support of another child who does not live with him or her. Likewise, other minor children which are the biological or adopted children of a parent who live in the parent's home may be considered as a hardship to impact the amount of support paid or received. If a parent resides with the other parent of the hardship children, the court can limit the hardship to a half a hardship, or in some circumstances, not give a hardship. Certain expenses which are required for employment, such as union dues, mandatory retirement, and some work-related expenses, are allowed as deductions from income. The court cannot consider many issues, even though a parent may want the court to do so. Debts cannot be considered except support orders or certain recurring mandatory expenses for work. There is no place in the guideline calculation to input the car payment, credit card payment, etc. Support of the children comes before any of these debts. The income of a new spouse of a parent is not factored into the calculation except to assist with determining the correct tax filing status of the party, or in some extraordinary circumstances. Child support, public assistance, and SSI benefits received cannot be considered as income. Other benefits, such as unemployment benefits, disability, and Social Security retirement, can be considered as income. The Family Code allows the court to divide the payment of certain expenses between the parents. Generally, these expenses are divided equally between the parties. However, Family Code Section 4061 allows for a different allocation if the court finds it is appropriate to do so under the circumstances. Family Code Section 4062 allows for a division of the payment of child care costs related to employment or the reasonably necessary education or training for employment skills, the reasonable uninsured health care costs for the children, costs related to the educational or other special needs of the children, and travel expenses for visitation. However, travel expenses are discretionary with the court and are often not divided equally between the parents. There are similar expenses which, as a general rule, are not allocated between the parties, although it is not uncommon for the parties to agree to share these types of expenses for the minor children. Such expenses are private school costs, which are not necessary for the special needs of the children, and extracurricular or sports activities for the children. The common practice in all the family courts is to calculate child support by use of a computer program. There are various programs in use and may vary from county to county. In Ventura, the courts use DissoMaster, or the Guideline Support Calculator. Both of these programs calculate guideline child support using the formula set forth in the Family Code. DissoMaster is a computer software program that is purchased from the vendor and is not readily available to the parties. Most family law attorneys have this program available and can run a guideline calculation for you. The family law self-help centers at the courthouse also have the DissoMaster program, as does the law library. The child support calculator is a computer program which is in use statewide in any case in which the Department of Child Support Services obtains a child support order. This program is available on the DCSS website free of charge. It is also available at the Family Law Self-Help Center. The parties can agree to a non-guideline support order pursuant to Family Code Section 4065. To do so, the parties must be aware of their rights to have the court calculate and order guideline support. They must agree to the following: that they are aware of their right to have a guideline support order, that this non-guideline order is in the best interest of the children, that the order is agreed to without coercion or duress, and neither party must be receiving or applied for public assistance. The parties know that either one of them can ask for a guideline support order without having to show a change of circumstances.